When you go to high court, at least you can expect that those individuals whom we address as my lord or lordship uh, would have some discretion, some mind that will be applicable in matters, especially in uh, matters where individual liberty is at stake. This is a wonderful example and shows that how much uh, judiciary lacks even at the high court, because when it happens at the trial court or things done by police officers, I'm not going to go or make a critique against them, because I know the ground reality, I know these people, I know where they come from. So uh, not applicability of the mind for anything when it comes to lodging an FIR or doing something else. I'm not surprised, and I'm not don't have any criticism or grievance against them. But at least that should not be the norm in the high court, because in order to reach even there, one really has to be some financial stability has to be there. I mean, in India especially, justice doesn't come freely or at a cheap price. It comes with a hefty amount. Now, in this particular case, apparently, this person, appellant, recited one poem in a meeting, and I read that, or rather, I heard that poem. It's a wonderful poem, which is there. Let me just see, where is it? No, not this one. No, here, yeah. Anyway, though I'm not going to. Uh, this particular matter got quite an attention in the media, and it even appeared in various news channels. So let me first go to the poem. So this is an Urdu poem which was recited by this appellant, and someone aggrieved by this lodged an FIR, and this appellant went to definitely trial court, didn't have any relief, went to high court, didn't quash it. uh, then the matter went to Supreme Court. The Supreme apparently quashed it. Now I'm going to show you what high court did uh, when it comes to adjudicating this application for quashing this procedure under probably 482. Now I would request, if you really want to know, or let me just give you the translated version, how this poem translates. So it translates something like this: those who are bloodthirsty, listen to us. If the fight for our rights is met with injustice, we will meet that injustice with love. If the drops flowing from a candle are like a flame, which is an analogy, we will use it to light up all paths. If the bodies of our loved ones are a threat to your throne, we swear by God that we will bury our loved ones happily. Those who are bloodthirsty, listen to us. Now, this certainly probably was written at the time when British were our masters, or they were ruling us. And this complainant filed an FIR because apparently, uh, I do not know it. I mean, I'm assuming that it was driven by some political animosity, because the poem has nothing that as such talks about at least the current regime, which is the present form of democracy. Uh, anyway, I'll not get into the details. So now, what High Court did is, this is the observation by the High Court. It says the learned single judge rejected the petition by holding that the investigation is at a nascent stage, means early stage. Interference cannot be made in view of the decision of this court in the case of, and this is a Niharika Infrastructure Limited versus State of Maharashtra. So, based on this judgment, which is again a Supreme Court judgment, the High Court held that since the investigation is at a preliminary stage, intervention is not required. Now, for a moment, even if I do not get into the merit of the poem that it violated, you know, or basically it's a freedom of expression case against that reasonable restriction 19.2, Article 19.2 of Indian Constitution. It's a case of that. And for a moment, if I keep it aside, I went to this judgment, Niharika Infrastructure, and in this particular judgment, the case was completely different. In Niharika Infrastructure, it was a case of 420, 465, 460, which is a matter of forgery, using some probably forged document or some financial instrument. And this matter in hand, this one, is a matter of freedom of speech, or at least hateful speech, something like that. Now, they are not at all on the same footing. They are two different subject matter altogether. Now, High Court using a different matter, or let's say, it's like you are using a liter to evaluate something that we weigh on probably kilogram or something like that. It is using a forgery matter, its judgment, wherein it was stated that since the investigation, because that was the view of Supreme Court, that since the investigation at its preliminary stage, intervention by the High Court is not needed. Let the investigation take its own logical conclusion, because forgery, if there is a prima facie case that yes, there was a forgery, it may be the accused is not the main accused, accuses somebody else. So that during the trial or post investigation that can be found out. But in this case, where a poem that clearly indicates, it probably refers to the time uh, of uh, colonial period, or maybe even prior to that, which was cited by this appellant. And the High Court held that investigation should be carried out, and post investigation. So there are a number of questions. The first logical mistake is using a different matter or different substance altogether to evaluate, taking a precedent from a different case altogether. you know Second is, this is a matter wherein you have, I mean, even if let's say that there is a poem which is uh, rebellious poem altogether, and somebody felt otherwise and filed an FIR, the High Court progressed in a very mechanical, without even looking into what the poem is all about, what its talk, what its indicate, or its implication, and without even looking into the circumstances where it was recited, where what was the intention. Because there, even for a moment, if I take that poem as some sort of anti-authoritarian poem that is meant for a a particular regiment, or maybe a form of government, the context has to be evaluated. And in this particular case, it was a wedding ceremony where this poem was recited. I think it is somewhere here. Let me show you. Just few seconds. Here, a mass wedding program was held at such and such place. The said invited the present appellant to function, and this is where actually this poem was recited. So, an high court, highest court of a state, taking a wrong precedent, or rather, at least using a precedent which is wrong to take in this particular context, because one is a forgery matter, another is a freedom of speech aspect. Giving a mechanical judgment or opinion is beyond judiciary, you know, I would say standard. Had this been happened with a trial forum, could have understood, or at least a reason could have been given. But from a highest court of a state, I do not know. And one other thing that one has to think now, since this person being a member of the Rajya Sabha, he has certainly had a lot of money, had power and everything, so went all the way to Supreme Court. But if this had happened with a normal or commoner with not so much money, what do you think would have happened with that individual? Nothing, harassment by the authorities, you know, endless harassment rather. We all know how those things happen. So, have a lot to think about, and rather lot to really think about uh, what kind of judiciary we have, what kind of judges are there, and many a times, even including I, blame police authority or blame legislative branch for not doing what is apparently or seemingly right. But when we look at our own institution, it's quite disheartening, and sometimes even shameful, I would say.